Hello, this is Steve Mullins, certified microbial consultant, and today's video title is a catch-22 for renters. Now, what are we talking about here? Basically, there's a clause that some landlords have put in their leases that basically says you're not allowed to have any inspections done on the property without their permission. Now, why is that a catch-22? Well, if you want to make sure your house is safe, let's say from mold or bacteria, that kind of thing, perhaps you suspect there's an issue and you want to have it checked out, but you don't really trust the landlord to be objective or to disclose to you what the results of an inspection they might do. And so you want to call someone like me, an inspector that does those kind of inspections for potential mold and moisture issues. But if the lease says you cannot do that without their permission, what do you do? Good question. Now, from a legal standpoint, I cannot give you a solid answer on that, except to perhaps consult an attorney, which I can give you information at the end of this video for that will help you in the economic sense. But besides that, what it amounts to is this. My consulting attorneys tell me this. If it is not disclosed to me by a renter that their lease says they cannot have an inspection without the permission of the landlord, I'm covered. I can still come out and do an inspection, tell you what's wrong, write a report and give it to you, and or take samples, mold tests, what have you. Excuse me, something just popped up on my screen. And that's all right from a legal standpoint from my perspective, because it was not told to me by you that you're restricted from having an inspection without the landlord's permission. Now, what if you don't know if it's in your lease or not? Well, you need to check. Now, does that keep it from being submitted in court? That report and evidence that there may be mold or moisture issues in your property? To be honest, I don't really know. Although my lawyer did say that does not necessarily exclude it. So these are things you need to be conscious of. Now, the idea is this. When you rent a property, look to see what it says about potential inspections. Now, not all landlords do this, but they started doing it apparently to try to minimize their liability. This way, they can keep a control on inspections as much as possible, so that way a tenant does not blindside them saying, oh, there's a mold in my property, here's a report. And they're going to come back and say, well, you weren't allowed to have an inspection done per your lease. Maybe yes, maybe no. But regardless, you do have the right to live in a safe property, and California law does require landlords, property owners to maintain the properties free of dampness and mold. That's Senate Bill 655, by the way, which is a primary law going into effect of January 2016. Now, there are other civil California codes that also protect tenants against this and other things that landlords need to maintain. So the reason they have to maintain the property free of dampness is because dampness leads to mold. Mold, of course, defined in the bill itself, means microorganisms, not visible mold necessarily. Microorganisms, of course, are the small stuff you can't see without the unaided eye or a microscope, which includes the dangerous bacteria that come as a result of water leakage or water being present in the home for probably a week or longer, approximately. And we'll talk more about that in another video, which I already have. So what do you do at that point? Well, you can have an inspection done if you want to risk that potential issue with your landlord. Unless you tell them you had an inspection done, they would not necessarily know about it. But you would at least have the peace of mind of what's going on, of knowing what's going on in your unit, home, house, whatever, and thereby take whatever action you need to keep your family safe. Now, again, I'm not a lawyer, I'm not a medical professional, but I know the basic principles of law in the sense that, hey, we all have the right to have a safe property, and the landlords are supposed to maintain it. And how do you find out if it's being maintained if you don't have it inspected? Now, you can have them inspected or ask them to. They may or may not. They might have it inspected, but then come back and say nothing was found. Well, how do we know? What was the credentials of the inspector? Where's the report? Well, by law, they're not required to disclose to you what was in that inspection. So they can say almost anything they want, unless you get a subpoena in a court case that requires them to hand over those documents. And then if they do have the property inspected, how are they having it inspected? What are they telling that inspector to look for? And what are they telling him to put in the report or not put in the report? A lot of little questions to think about. So keep this in mind, and if possible, do not sign a lease that says you have to have their permission for an inspection. Or if it does say that, perhaps you can have them modify that to say that they're going to pay for an inspection if you ask for it, and that they need to disclose the results to you, which of course they're not really going to want to do, but that's what you might be able to try to do. Again, you might want to consult an attorney if it's going to this kind of a situation. And if you click the link on the end of this video, or should I say below it, you submit your email, and I'll send you a PDF that will help you in that regard, and you can get that rolling. Anyway, that's all for now. Thanks for tuning in. Have a good day and stay safe.